I just wanted to revisit, I know some of this might be a little redundant, but I just wanted to revisit labor and labor markets related to the merger stuff. So, and Ms. Wilson, you can comment, Mr. Kobayashi, again, feel free to chime in. There have been reports regarding FTC sending companies questions that are kind of far outside what you would expect traditional inquiries to be about as a result of the merger investigations. An example is, and I know this can be kind of dismissed as, boy, I've never heard about that before, so I'm trying to raise the profile of it, but FTC staff has inquired about how mergers would affect unionization, as well as some environmental and social issues. This is, to my understanding, this is a departure from typically what you may see as, what we would consider traditional questions. And some of the other witnesses on the panel have discussed the need to change antitrust laws so that the effects on labor markets are considered. Seems to make sense to me. You both served at the FTC and understand the relationship between the mergers and demand in the labor markets. Can either of you discuss how current antitrust laws and enforcement considerations already account for this issue? Ms. Wilson, would you like to?
Sure. So thank you, and I'm sure that Dr. Kobayashi will also have interesting comments here. So to be clear, the horizontal merger guidelines actually do say right now that monopsony powers should be investigated within the course of merger analysis. And so as Bruce outlined, for at least 3 years under Chairman Simons, we did look for labor monopsony issues in mergers. And so we included specifications in the so-called second request for information of merging parties that sought to analyze the impact of mergers on hiring. But what is happening now, I believe, is going further afield and looking not at what happens for competition for labor, but for other social values. And I disagree with expanding the scope of antitrust beyond competition, which is a load that it is designed to carry. We are not equipped to evaluate the other factors that are now being shoehorned into antitrust analysis.
Thank you. Professor?
Yeah, I want to comment maybe on some of the comments saying that we ought to do something to maybe make thresholds for labor market. If you go back to the Prager and Schmidt article, which is a very good article, I want to make 2 points. One, if you look at what mergers, and they base their concentration numbers on commuting zones, so it's not a product market. It's a commuting zone. You have to go into sort of the extreme quartile, and that's Herfindahl's of about 6,000s with changes to about 2,000 of the mergers that sort of generate the wage stagnation. The other thing that you have to look at is that they test for output effects and the effects of classical monopsony, and they don't find any. It might be that there are bargaining effects, but it's not sort of classical monopsony where you have independent decreases in employment. And then it's limited to skilled workers. But if you were based on the evidence, you would basically put those thresholds at 6,000s, which are like basically a 3-to-2 merger. Those mergers probably will get blocked on product market grounds or on the standard tools that we have. But as I said, and as Commissioner Wilson just reiterated, that we have adjusted our enforcement procedures, including the HSR specs, where we get information to actually look at product market and labor market issues. And I don't know what else you do if you want an evidence-based enforcement of the antitrust laws. We try to get the evidence.
Very good. Thank you.